Working session, please come to order for October the 18th, 2011. Mr. City Manager.
First item, Mayor, is a continued discussion concerning the revisions to the ethics ordinance. That was recommendations, as you know, were given to us by the Board of Ethics, and our purpose today here is to further deliberate on these recommendations and to acquire the Commission's input as to them. Mr. Waltrip asked us to put this on here today, and I think he's going to lead in the discussion.
Is Gene going to be with us?
Yeah,
He had a new grandbaby.
he had a granddaughter born, so maybe he's at the hospital. I didn't hear.
I think ethically he's done the right thing. by
Yeah,
going with the
ethically, I
granddaughter.
think he probably does.
But we can discuss it. Obviously, we had the committee come before us several weeks ago, and I know after that presentation, there's been some comment wanting some clarification on a couple of areas of the recommendation. So I thought if we could flesh those out today, and we may stand a chance of getting this where we can actually vote on it. So I know Bruce and Slim, probably all of them have something they want for clarification. So
Why don't you,
how
excuse me, why don't you start us off and
well,
with your concerns, and
well,
we'll just go around the block.
I'm probably a little bit in the minority in this, or I may be, and it may be just that I don't have the ability to be as detailed as I should be, but I was okay with the way it was presented. But I think that there are, in talking with several members individually, I think, again, I think there may be some misgivings about not enough clarification on a couple of issues. So if someone would like to start off with some of the reservations, again, I was okay with the way it was presented. But
Bruce, Melinda, Slim?
I'll start.
Okay.
Most of my questions relate to number 9 of the ordinance as it's currently written.
Well, you on page 3, Slim?
I'm on page 3, number 9, and I'll just kind of list them all at once. One is unethical. I have an issue with that particular word because I don't know who defines unethical. Moral turpitude is also questionable because as moral turpitude is defined, at least to me, it stands for things like good morals. And I want to know under this code who would be defining the morals. Number 2 within number 9, conduct that calls into question the public official's ability to perform his elected or appointed duties. Number 3, conduct that harms public respect for the city or confidence in the operation of city services. And then dropping down to number 5 within number 9, conduct that impairs the operation or efficiency of the operations of the city. Each of those, it seems to me to be wide open. Now, I know what my morals are. I know what my ethics are. I personally believe that they're high in both areas. But that's for me to define. Somebody else may have a different take on ethical or unethical behavior, or high morals or low morals. And that kind of applies, I guess, to all of everything that I outlined. Number 2, conduct that calls into question the public official's ability to perform his elected or appointed duties. What conduct could a public official engage in that would interfere with his or her ability to perform the elected or appointed duties that would not also be illegal. Illegal to me is an easy one. You're either in or you're out. You know, you're either arrested or charged or you're not. And so I appreciate and understand what we're after here. I just don't know why why it's recommended that we go further than illegal behaviors, simply because that's easily defined, not left to subjectivity. And I, verbalized in the last meeting, conduct that harms public respect for the city or confidence in the operation of city services. That one seems even more wide open to me, and maybe it's personal. Maybe it's because, I've been accused of these things sitting in the very seat I'm sitting in. You serve on the ethics board. You know when my name comes up to you all. Now, allow me to clear the record that nothing has ever gone further than any of that. But while I think it's unlikely to happen, I could see the possibility that a board becomes stacked in a particular way that it doesn't care for one particular board member, whether that's me today or a commissioner 20 years down the road. And so suddenly they're able to define what is confidence in the operation of the city, what is public respect for the city. And 5 and 3 really seem to me to be 5 and 3 within number 9 seem to me to be the same thing, or at least the same concern that I have on them.
If I could, and I don't bring the experience that, that Slim or Joel or Bruce do to this issue either. Just having begun in January in this position. But the ambiguity, I guess one reason I'm fairly comfortable with it is that there's, even in legal terms, enforcing the law, which obviously was involved in for 32 years, there's ambiguity in legislation when it's written. And then you have to, it has to go through a process to actually see what was meant and let the courts decide. And let me, Kevin, you might help on this, or Gene. Okay. If something's brought forward, an issue would go to the ethics committee first, right?
Good.
And
Gene,
so you have a group that's going to look at that and decide some things right there. And I guess the fact that Slim, that you had some issues come up and didn't go beyond the ethics committee probably reinforces my thought that I don't think we're going to get everything nailed down into specifics. And I guess that's why I'm okay with ambiguity of some of these things. But again, I don't have the same experience that you guys do. So.
I guess if anybody on the board or anybody else, I cannot think of examples for myself at this point. This may show my own limitations, but I really try to think about conduct that calls into question the public official's ability to perform his elected or appointed duties that's not illegal. Can somebody shoot me, throw out an example there that, Kevin?
I'm just speaking from
Sure.
From this thought here. What if you were by accident to use a bad word over the microphone? In some people's mind, that might be reason for you to not be able to serve in a way representative of the values of this community. Is that
Right.
an example?
We all go.
And that to me is
By accident, of course.
is a great example of why I think this is too broad. I've done that right here in this seat. I took the Lord's name in vain one day and burnt my email up. Now, I don't think anybody filed an ethics violation against me. I'm embarrassed by what I did. I apologize to everybody who contacted me about it. But is that really something that we want to spend a lot of time and resources on because I don't show any more intelligence in the type of language that I use when I get frustrated. And that's what I'm talking about. I can't think of anything, and again, this goes back to my own subjectivity, but I can't think of anything that's not also illegal that then, in my opinion, rises to the level of calling into a question my ability or any other person's ability. I mean, we have had some spirited debates up here, especially former Mayor Elaine Walker and I, who, since I mentioned her name, wish her the very best in her battle with breast cancer. Politics is politics, but that's a very serious issue. I wish her nothing but the best. But in our spirited debates, I never thought she crossed a line where I thought, wow, you know, that's so out of bounds. And there are times that I even said, I think you're out of bounds. But that's more about public decorum than it was about, you know, somebody not having the ability to continue to perform their job.
If I could speak, I'm sorry for being a little bit late. I missed the first part of this discussion, but
Congratulations, by the way, before you get started.
well, thank you. 19.5 inches long, 6 pounds, 10 ounces.
Very good.
Lucy, just cute.
That's a grandbaby.
Lucy.
Yes,
Yes.
yes, yes,
Thank you for clearing that one up.
yes. But I think when we started talking to the ethics board, I think the ethics board, and I'll let the ethics board members speak for themselves as well, but I think the ethics board had in mind some activities that still could be ethical issues that necessarily were not illegal. You could, I think, still could do something and commit an ethical breach that perhaps is not in itself illegal. I guess a couple of things come in my mind is what could conceivably be an illegal act, but the prosecutors decide not to prosecute. We've had a situation here in the city in the past where we actually had a matter where we had an employee suspended, for example, while criminal proceedings pending, end up going to trial and get acquitted. I would tell you that would not have prevented, that acquittal would not have prevented disciplinary action, because different standards of proof, different issues. So you could commit an administrative violation of the city's personnel policy, yet not have committed a criminal act because, in fact, they were acquitted. But also, I guess the main thing I want to say is, I think this, it was some, and I know it's tough to do. We've had different ethics boards through the years, but the policies in place now, the ethics board, if they get a complaint, they're going to look at it initially themselves to see if it even rises to any kind of a level, any type of a, you know, like a probable cause, I guess, the decision whether it even rise to that level to go forward at all. I think the last one or two they've looked at, they've said we're not doing anything with them. We just don't think there's anything to it, and we're not pursuing it at all. Then after that, you know, if they do decide, depending on where the ethical complaint is directed at, if it's staff or something like that, then I'll do the investigation. If it's an elected folks, then they'll bring a special investigator to look into it. You know, that investigator has to investigate, you know, look at the code and make a recommendation to the board as to where they feel that there's any type of an ethical breach or ethical violations here too. Then the board, of course, has the authority to either accept or reject those recommendations. But I think the impression I have from the board when they were looking at this issue is, I don't think they wanted to limit ethics violations just to criminal acts, because there still are acts and activities that they considered may be ethical breaches that, you know, may have been criminal, not prosecuted, may not have been criminal at all, but still may represent some ethical concerns to them.
What might those be?
Can I give you a prime example? I'm not sure I can.
Okay.
I mean, you know,
That's what
yeah.
and I'm not trying to get stuck in this and hijack the meeting and talk about it, but I really tried to just think of what conduct somebody might engage in that's not also illegal,
Well, let me.
that would
I think we
then
all-
interfere with that person's ability to be elected or appointed.
Well, I think we all know, I think the activities that probably led to the ethics board looking at this, those activities ended up being pursued criminally, but the prosecutor's office could have decided early on that those were not worthy to prosecute and basically made a decision that we're not going to prosecute them. So criminally, they could have ended. That, I think, still would have left the ethics board in a quandary about what do we do, because they're getting complaints over the ethics line about the activities that led to those complaints. well, what happened last time it happened, they spent $6,000 or close to it, retaining special counsel who came back and said, there's nothing in the ethics code that covers this.
Is something illegal if you're not convicted of it?
I think it could be. You can
It's
still
almost
commit-
like, it's almost like going to a criminal issue, or do you do it civil? You may be found not guilty even in a criminal proceeding, but in a civil case that requires much less proof, you may be found, and the word's not guilty. The word is
Judgment.
something else, judgment against them.
I mean, you could commit a criminal act and still be acquitted of the crime. Because of standards of proof and other issues too. But I think, I'll let the ethics board speak. I mean, they're the ones kind of, I guess,
So that,
wanted
that,
something done.
that opens it up. So let's say, I need to quit using myself. People will call this out. And one day I'll be running for office, and the next thing I'll hear is, I take the Lord's name in vain.
Let's use Gene.
Let's use Gene.
Why not?
I guess that opens up another whole can of worms for me, that you engage in behavior that either a prosecutor or a court determines that doesn't have enough merit to proceed, I guess is the correct way I would say it. But yet then you could lose your position as an elected official. I don't know, and please don't misunderstand me. I'm not opposed to ethics. I'm just,
Well, I want to
The
make sure you understand,
standard-
the ethics board doesn't have the ability to remove you off from office. I mean,
I understand that.
Does it mean that the standard is much higher in a criminal prosecution than it would be the level of proof that would be needed to prove an ethics violation?
I don't think so. It's not a
And
reasonable
then
doubt
and I'm not talking about Slim, but I think that's Slim is having that.
But a civil
issue.
matter, for me, my limited experience working in the court system is an entirely different issue than a criminal issue. I mean, I see them as separate. I understand that a lot of times people who commit illegal acts and are not found guilty of them are later pursued civilly, but I think that's sometimes because they
But if I
feel
go back
like
to
justice was left unserved, and therefore,
If I
you
go
know,
back to personnel, and we're going to talk about personnel policies, I think, in a few minutes, in our disciplinary section, I'm not sure the word is ambiguous, but there's lots of issues in there, things that you can be pursued because of administrative violations for disciplinary actions. Some of those are borderline, could you have committed what potentially could be a criminal act, yet due to the nature of the act, the county attorney's office basically say it's not worth our while to prosecute this thing criminally. Yet we certainly would still have the ability, the city manager could, to pursue it on a disciplinary matter, even though it may be a borderline criminal act, just because, we're not going to back off on that issue because the county attorney's office says we're not going to prosecute it.
I'll step down for a while and let some other people.
Bruce?
I had a lot of questions in the same manner that Mr. Nash has, but if I could start on, I guess it's number 7, becoming delinquent.
What page?
Still 3.
Item 7 says become delinquent for a period of more than 45 days to the city or any city board or agency. Delinquent in what?
Well, that one's been there for a long time. The only thing we're adding is the underlying part of this one, the city or two. That's what we added to make sure this could refer to delinquency in city taxes. Delinquent to a city agency could become any one of the boards or agencies that we created. If you owe money to them, BGMU, any of the others that we created.
So this is just owing money to whether it's your yard, you're not mowing your yard, or a code violation fine or something like that.
I think it'd probably go that far if in fact there was a assessment, some kind of criminal, or not criminal, but civil penalty put on a city commissioner and they didn't pay it. Of course, there's something else down here that may pick that up as well. But
Is there a reason why we only did the city and not state or federal agencies?
This one has been here for the majority for probably 10, 12 years, Katie. This was under Mayor Renault. I think he's the one who recommended this one. And the only thing we added this one, we added the language to the city because I wanted to make sure that, because before it says to any city agency, which may have opened up the door, you could be delinquent to BGMU, it may have an ethical violation, but be delinquent to the city of Bowling Green if you interpret it a certain way and not be subject to it. And I think it made a whole lot of sense that that you could do one and not the other. But
Do you think, is there a reason why we haven't included state or federal agencies too?
I think just at the time that this was recommended, they didn't recommend that language. We certainly could if everybody wants it. This one was an elected official recommendation.
Is there a reason why, going down now to the questions that Slim asked on 9 under subsection 1, moral turpitude, is there a reason why we limited it to that, not include, violations except traffic violations?
I'm not too sure this one is that unusual from a lot of state statutes and other things that, everybody puts felonies in one category, misdemeanors in another. Sometimes there's some separation of misdemeanors. For example, and our first example is, the Ethics Board may not agree with me. I'm not too sure if a single DUI, to me, involves a misdemeanor with moral turpitude. I saw some distinction, at least when I drafted this, I saw some distinction in potential types of misdemeanor convictions that I didn't, it's like every other conviction. I didn't put maybe all of them in the same vein. There's quite a few statutes out there that have similar language that, and I can't remember which ones, but I'll pick out one. Pharmacists, for example, may have the same thing, that you can have your license revoked for conviction of a felony or a misdemeanor involving moral turpitude. Similar type language as well. I can't remember if it's that one. I will scare pharmacists out here, but there are some statutes out there that have similar language.
Well, I understand and don't necessarily disagree with it, but I didn't know why we stopped there and didn't include, because we went through under item 4 and included, violence or abusive behavior, which includes intimidation or verbal threats, which are in Kentucky law are, I think, mostly violations now, not misdemeanors. So I thought you could probably cover all that without delineating.
I'm sorry, which one are you looking at?
4.
C.
Yes.
I think, at least in my view, when I'm looking at C, violence or abusive behavior, which includes intimidation and verbal threats, I don't envision some of those as being criminal matters. That could be
A violation.
bullying city employees. Something similar to that may not even rise to the level of a criminal issue.
How are we, just as a matter of trying to get through this, and are we going to have each person bring up their individual issues and go through it, or are we going to try to come to some type of consensus as we go along, or which would be the most efficient process?
I would hope we wouldn't have to spend the whole working session period on this with having another agenda. And it's not on the agenda tonight.
No.
Again, I won't speak for the board, but I think the board would welcome, any suggested language. I know they had the one at one time that they looked at, but I'm sure, I don't want to speak for you.
Bruce, you still got something that you want to ask?
Not if nobody wants to talk about it.
I guess what I'm saying is when Bruce went over number 7, and he said, should that include state or federal agencies? I don't have any problem with it including state and federal agencies.
We're stretching it a little further when we get, where does the personal, because you're an elected official, where does the personal, are we in the personnel business to the fact that if a person owes $400 to the Internal Revenue Service, that makes that person a bad person in the world?
Well, it says that if we owe $400 to the city, it is, according to what's been in place for a while. So that was my question.
Well, that one's been here for, Katie, since about 1995, 1996. probably somewhere in that range. I would tell you, along that same time, there was another one proposed, and I did recommend that that one not go forward because there was a proposal to make it an ethical violation to file bankruptcy. And I did have concerns about that because of the federal bankruptcy protection, about you can't retaliate, you can't take adverse action against somebody just because they filed bankruptcy. It's a statutory created right to do that.
Melinda, you got a list?
As far as in item number 9, number 2 and 3, I believe those are defined every 2 years. If our conduct is not, if it's into question or if it harms public respect, I believe the citizens of our city will take care of that when they go to vote every 2 years. So I do have an issue with those. I mean, not that I agree we should have, good conduct and we should do everything thinking of the city and do it respectfully. But I do believe if our conduct is in question, the citizens will take care of that.
What if an issue comes up, and I understand what you're saying and don't disagree totally. What if an issue comes up the day after you're elected? And then you're able to continue serving out your next, ever how many days that is, without any recourse that the citizens would have during that almost 2 years. Would that be an issue?
Good point.
And again, I think that the public would exercise the right not to vote for someone if they felt like they had violated this, but
I saw all these as a stopgap measure until the next election. I mean, it's
What if we put somebody out and then they get reelected in?
well, and I guess I kind of saw some of this, and I'm not trying to beat a dead horse, but in the same way, I know term limits come up all the time in federal races. I don't support term limits because I think the public's smart enough to vote people out when they don't want them anymore. And no matter what I may think of any one person, it's about the collective public say when it comes to voting. But I do see all these as in a situation like Mr. Waltrip described as, you're a day or a week or a month into a new 24-month term and you do something, then what happens next? Although nothing in this ordinance indicates that anybody's ever going to be removed from office.
Well, the only people who can, and maybe other things, but I was going to mention some other thing. It'd be nice if every statute was crystal clear. I say that almost every day when I read them and try to interpret them, half of them figure out, I don't know what the state's saying either, which doesn't excuse this, but this body has the ability to remove any one of you for misconduct, undefined. Somebody want to tell me what misconduct is?
No.
Who does this apply to? It doesn't just apply to us. It's every board member on any agency that the
With
city has.
specific state statute dealing with on boards, commissions like this, councils and commissions, and I think this may be a particular city manager language, but said in this kind of a board that this body has the ability to remove other members for misconduct.
And I'm talking about this ethics ordinance applies not just to 5 people, it applies.
It
Lots of
also
other
applies to
situations.
employees.
Mm-hmm.
Yeah.
I mean, at the top of this, standards of conduct, no public official or employee of the city or members of the board of any city agency is defined here and above shall knowingly. So, I mean, it is more than just about the 5 people who sit here. Again, I guess where I'm most comfortable is it's either illegal or it's not. You're either in or you're out. You're either convicted of a crime or you're not convicted of a crime. Does that mean somebody can't be suspended, pending the outcome of some investigation? I'm not suggesting that, but I think those are more internal things that the city does. I know that from an employee standpoint, that's handled by the city manager. From an elected standpoint, it's really handled by the 5 people that sit here. I know of times that people who sit in these seats have gone to another elected official and said, you know, maybe a break is in order. So I don't know. I think the intent of everything that I'm reading is pure.
Oh, yeah.
It's the implementation where things tend to.
I actually went out, and I know they did, the ethics board did as well as Gene. You go out and look, and you can't find language. You know, most ethics ordinances are simply financial conflict of interest things. They don't deal with behavior of either elected officials or anybody else. So we're I don't say making it up as we go along. We're crafting this or charting new territory, I guess.
Prior to this, not word for word, but probably if you could go to every city in Kentucky and 95% of the ordinances, ethics ordinances said the same thing, because they were all financially driven. You're absolutely right.
And it was the model ordinance presented by the Kentucky League of Cities. Is what
It's financially driven, not behavior driven.
And I think there's. Go ahead. Yes, sir.
No,
I'm sorry.
I was going to say, I read through this, and the thing that was most problematic reading was number 9. The thing that occurred to me, there's the issue of broadness needed for purpose. Okay, you can't define every situation, so you have categories, then you add a coverall for that particular category. Theft, non-payment of bills, drunkenness, and immoral behavior. What was especially problematic was number 5, conduct that impairs the operation or efficiency of the operations of the city. That raises the question of unnecessary ambiguity. For what purpose? It's not focused to any one particular area. It just seems overreaching. I don't know what that would be. So if you all have arguments and the citizens do a referendum and say that you or I are hurting the operation or efficiency of the city, is that something that is an ethics violation? It just seems so broad. It seems overreaching. It didn't seem broad for a functional purpose, money, non-payment, moral turpitude, but when they threw in the operation efficiency, every citizen can make that question every vote you make. It's not directed to a purpose, to a functional area.
Is this something, or talk about taking it back to the ethics committee for their review? Could we agree that everything with the exception, and Bruce, this may bring up your section 7, but everything with the exception of number 9 is agreeable? Send this back to the ethics committee, let them review our conversation that we've had here, and see if they can make another recommendation that they could support. Because again, I think it's part of this process is important for the group of citizens that we've tasked with this mission to be on board with it. And I know there's probably problems with what I just said, but basically, generally, that's what I'm thinking. To have that group of people say that this is acceptable to them as well, and to see then if we could get a consensus after they looked at paragraph 9.
Sounds great to me, because if we continue here on number 9, we're going to be here all week.
And with that, Bill, is it possible to combine 7 with elements of 9? Because under 9, what is it, 9C, it speaks.
4E, 9-4E.
Yeah, E. It speaks to almost the same issue that, or part of the same issue found in 7 by itself. So.
Yes, ma'am.
Yes.
I know in our discussions that we feel as though now we have given this document to you to make decisions on, that we have struggled and thought about this and talked about this for a very long time, and this is the document that we came up with. And so I think as a whole, as an ethics board, we feel that it's now your time to take what you like whether it's all of it or some of it, and then decide whether you want to move it from the working group onto actually a commission meeting and make a decision. Of course, if you say you're going to send it back to us, we would, obviously we would be glad to look at it. But I think that really goes against what our hope is at this point.
So you're saying that you don't want to get involved in what we're doing here. You don't want to do that again.
Well, we just feel like that we have thought about it and struggled with it for a long time. And
You've
now
done all you can
it's,
do.
Yeah.
it's your time to maybe think about that and struggle with that and decide, where do we go from here? Do we take part of the document? Do we not take part of the document? And what is best for the city? So,
Will you be kind enough to introduce yourself for the
I'm
people who
Dr.
may be
Amy
watching?
Capisi, and I am the Vice Chair of the Ethics Board.
Mayor,
Linda?
I would agree with Amy. They've spent a lot of time on this already, and I think we just need to buckle up right now and just start saying what we all agree with and what we don't agree with and move on. Just get it done. Get it ready to go before the commission for a vote.
And I guess the issue that I had about sending it back, you just took care of. Because if you all are satisfied.
That's just my recommendation.
Yeah, if you all are satisfied with what you just said, that takes care of my concern that your group have further recommendations or comments, and you just took care of that, so good.
Let me make a suggestion, good, bad, or indifferent. Apparently everybody has some problems with number 9, section number 9. We've gone this far. Why not put it on working session at the next meeting, regardless of how things turn out, and be prepared to present it in its final form? How about that?
I'll prepare something and get it for everybody.
Is that all right, Slim? Bruce is going to prepare something and get it in the format for us, not the Ethics Committee, and we work it out, and when we say that we're ready, then we'll have it on the agenda.
I have no objection to that.
But we may have to have, Bruce, one more working session.
Sure. I'll send it to everybody to review, and you can send back if you want any changes. and we'll
Okay.
vote on it.
Are those changes that you're going to do, is that based upon what you believe
But I think I'm hearing here.
the issues? Okay, yeah, I'm good.
Right.
Now, I may not have heard it the same way that everybody else.
But you're going to talk to
I'm
each
sure it'll
one
be-
of us anyway.
I'm sure it'll be
As long
fine.
as you hear what's going in your right ear.
Everybody understand what we're saying?
The one thing I just want to make sure that we don't do, and is I've heard up here just in today's discussion that, well, other laws are written with ambiguity, so why not write our law with ambiguity, because we can't define it. And I also hear that because of things that have happened in the past, there is a need for some type of reaction. And what I want to prevent us from doing is, I don't want to react with ambiguity simply because it's in the interest of simply reacting, or simply because others have reacted with ambiguity. I want to stay away from that, and if it takes us a long time to hammer out what it is, then I think it ought to take us a long time. But I think every citizen at some point has looked at something and scratched their head and thought, what were those people thinking when they implemented this, because it is so open to interpretation. I'd really like to try to clearly define you're in or you're out as much as we can on this.
And I guess this horse that we're beating to death,
Is what they
I'll keep my other comment about the horse to myself, is that, again, my point is that I think the process in and of itself holds some safeguards, and by saying that this will be a little bit ambiguous is not saying that it will not be well written or framed in such a way that would protect all the people that fall under it. But what I'm saying is I don't obviously think that we can be so specific that it lists exactly what is, what would fall under this. But again, I appreciate what you're saying, and I think based upon our discussion, I think we can come up with something that we can all live with. Okay.
Any other? Thank you for being present with us again. We're gonna run you to death. Thank you. Bye-bye. Mr. City Manager,
Mayor,
item B.
as the commission knows, we have an administrative personnel policy. We do not have union contracts here. We attempt to manage our personnel system by certain procedures and protocols. Those need to be updated every so often to reflect changes that you all make or changes made in federal law or in some cases common sense. We've been working on, I think the last time we changed this, Michael, was 208? 206. So it's long overdue because I know we have made a number of changes in the policy in the last 5 or 6 years. So we've been working on this administratively, and Mike's here to present the findings. We used both the employee groups, and there are some of their input, as well as senior management, and then Mike as personnel officer. So I'm going to turn it over to Mike, if that's okay.
Can I ask a question before Mike starts? And this is just from Joe Denton, I guess. Something like this right here, and we're having a working session on it, which means in most cases it's not going to be on the agenda tonight. It will be on the agenda sometime in the future. But when we have a presentation like this, is it possible for us to see these documents before coming to the work session?
It's in your packet.
It is?
Yeah,
I overlooked it, I apologize.
right here.
But some of the things that we have in the working sessions, we do not put in here, and we only hear it when there's a presentation.
Sometimes those things aren't ready to put in. You got to remember that by Wednesday at game time, I have to put together the agenda. So I have Thursday morning by 9 o'clock and predict all the information I'm going to need you're going to need by next Tuesday, or really by Thursday night when you pick your packet up. I have 1 day to act. Sometimes we don't get information until that morning. It's incomplete. So we wait another meeting and hold off action. It's our opinion, we attempt to share as much information as quickly as we can.
Okay, Bruce?
Yeah, I'd like to support Mr. Denning in that it hasn't happened this meeting, but generally when we come up here, we're handed more material for decisions that we end up having to make that night. That's kind of frustrating from my standpoint because I feel an obligation to review that material before I make an educated decision. So I understand his question because I understand your frustration because you're time limited.
I only have a half a day to get everything you need and figure out whether it goes on the agenda. 1/2 morning. That's what I have.
But I would encourage you to change that schedule from your staff standpoint if you needed to.
You have 2 meetings a month. We went through this with you too a year ago. We have 2 meetings a month. The agenda review is a Thursday before the meeting, a Wednesday before the meeting. So there's not enough weeks in the month. The only time it's even remotely manageable is when you have 5 meetings in a month. What we can do is push off stuff to give you more time. Now, that may be a problem in terms of contracts, delays. We truly make an effort to give you everything we have. You get it first before anybody gets it, other than the day I get it. If I can send you by email, we usually do. But the only way to manage that is push off the time to another meeting. So For example, these documents here, even though we've seen it, Mike and I reviewed it Wednesday morning. That's the.
Well, we had these documents, though.
Yeah, but the amount of time, for example, we'll have a meeting today. By next Wednesday, right, we have agenda review. So the departments have Thursday, Friday, Monday, and Tuesday, 4 days. I get Wednesday morning. You all get Thursday, Friday, Saturday, Sunday, Monday, and Tuesday. There's just not enough time unless you cut back to one meeting a month.
What if the compromise was that no item is put on the working meeting, no item is put on the regular meeting agenda on the same date that it's put on the working meeting agenda?
Will that apply to outside agencies as well?
I'm fine with applying to everything.
Yeah, I don't have no problem applying to everybody.
I mean, I can see that there are pitfalls to doing that.
Right.
The biggest pitfall being, time management. I mean,
And speaking of that, can we put a time, this document here, even with it being up on the board there, probably it's gonna take some time in this presentation. Do we have to have on the working session agenda 3 or 4 presentations based on the time that is needed to present a particular item? Just have it being the only item, unless it's something that is pushing us in order to get out, get signed, and delivered.
I'm trying to understand.
That's all right. Go ahead, Mike.
Good afternoon. This is a compilation of a couple of years' worth of work. Hopefully, once we have a new manual adopted, we'll have revisions to you more frequently in the future. What was provided in your packet is the actual draft of the manual with changes highlighted or deleted, and then also provided you with an 11-page spreadsheet highlighting the more significant changes. What we have here is a 7-page summary of the summary. We've tried to eliminate the items that aren't that significant in changes, but obviously if you have items that you don't see up here that were in the other summary or elsewhere in the document, feel free to ask questions or bring them up as we get through this. And again, we do not have this on the agenda tonight. It'll be on the agenda whenever we're ready to present it after hearing your questions and comments. This is the manual for classified or full-time employees. We also have a manual for non-classified or part-time employees, although a number of the policies are similar or identical. Once we go forward with approving changes to this manual, we'll ask that you adopt the changes that affect part-time employees as well. Just kind of going item by item again, unless you have any questions. There's a disclaimer at the beginning we've added that combines some sections. We have references in the past or in the current manual to at-will employment. However, we have so many protections for employees, either in our policies or due to state laws. We have removed most of the references to at-will employment. That doesn't mean that we're changing how we feel about that. It's just it's hard to say you're an at-will employer when you've got state codes that say you have to do certain things when you're involved with certain employee groups. We have included a reference in here to the possibility of the city manager being able to approve interim changes to the policy manual pending your later approval that would allow us to make some minor changes without having to come back to the commission each time. The exceptions we've listed are related to leave earnings or benefits. Those would be required to still come back to the city commission for approval. The second chapter has to do with pay and classification compensation. A number of changes in there. When we adopted the pay plan in 2006, it envisioned biannual steps. We did that for 2 years, then had to stop for 2 years due to the budget. Reimplementation this year was that we're now doing annual steps, but half the amount, so we're including that language in the manual. Also, senior managers treated a little differently. They're not automatically eligible for a step increase, but identifying how they would be treated, also allowing the city manager to give more based on meritorious service.
Are you going to take questions as we go along, or?
Yes.
Can you help me understand what the difference between a performance increase rather than a step increase is?
A step increase, we identify in the pay schedule the exact dollar amount of what the steps are. If the employee is satisfactory, they receive that step increase. The schedule for senior managers or department heads does not have an identified step amount. You've got the minimum and the maximum. So what we've identified in the proposed policy is to give senior managers the average of what the other employees get, but the city manager has the authority to give zero if he wants to a senior manager. Therefore, this would, if based on the performance evaluation, if he feels the senior manager has done an exceptional job, would give him the flexibility to give, say, more than the average that the other senior managers would get.
I understand what you're saying there. I don't know if I'd be on board with going above the average part of it, just because the board generally approves whatever the increase is going to be, and those increases are up to that amount. So I'm not sure I'm on board with that part of it, but I understand what you're trying to tell me now. Thanks.
Okay. Mike? What employee groups have special protections through state law other than the fire department and police department?
Those two.
So we're going to eliminate all reference to at-will employees for those two departments?
Because of those two, you mean? Well, yes, I mean, it's not just the state code. We have other provisions in the manual where, for instance, we've added a provision that if someone's going to be disciplined, terminated, that they'd be allowed to have a predetermination conference with their department head. So we feel like there's enough protections in the manual. The city code refers to us having a merit system that really referring to being an at-will employer in the manual really doesn't mean anything because we don't truly act that way. I mean, we bring a termination to the city commission rather than just administratively terminating a non-police or fire employee. We just didn't see any point in calling ourselves an at-will employer when the city code says we follow a merit system.
Very well. Thank you.
Explain how we do have a pay grade where employees can be between a minimum and maximum. If we have an employee that reaches the maximum, we describe in section 2-4.3 how they would get an equivalent of a step increase, which is basically a one-time. It's not added on to their base rate. It would just be an additional payment that 1 year. An item added regarding overtime with daylight savings. As we approach the spring forward, technically people working shift work one less hour because we now pay based on the number of hours people work. That technically would mean that someone working an 8-hour shift only works 7 hours. They would only get paid the 7 hours, but the policy says the department can work them an extra hour or they can take an hour of paid leave in order to complete their shift. In the fall, of course, with fall back, they end up working an extra hour and we pay them the extra time, of course, by law. Comp time, our policy presently states that at the end of a quarter, employees have to either use up their comp time or they get paid for it. Federal law allows accumulation limits that we have not been following in the sense that we're more strict than that, not that we're not following the federal law, but we're more strict than that. The proposed policy would allow some hours to be carried over from one quarter to another, and then obviously if they reach that limit, we'd have to pay them for that. That would help, particularly Parks and Recreation, where they have people working a lot of hours in the summer and then during the winter times not working as much. That could actually help them save some money by not having to pay out as much overtime. So again, providing some flexibility to allow people to accrue some comp hours, but still staying within the limits required by federal law.
What happens when they retire with that?
If they're non-exempt employees, we have to pay them for those hours. So exempt personnel, we do not.
Mike, I've asked this question before, and I'm sorry to ask you again because I've asked you specifically. Are employees hourly employees or salaried employees?
Most of our employees are technically hourly, unless they're exempt from the overtime requirements. Our pay schedule refers to things in an annual salary, but we've converted the starting rates to at least hourly show that. So I know we've discussed that many times. We just don't seem to use that terminology as far as salary and hourly. It's exempt and non-exempt.
And I understand the difficulty with the terminology. What I don't understand is that beyond my role at the City Commission, I work a salary job. That salary job required me just this past Saturday to be at the Capitol at noon, and I left the Capitol at 10. My employer doesn't pay me any additional money. They didn't tell me to take Monday off. They didn't say you have this many hours coming. It's just and I know when I accept it, it's part of the job. Do I wish they'd pay me? Do I wish they'd give me time off? Sure. But when I took the job, I knew that there were going to be times that I was going to be required to work that was just part of the job. So I get confused with the city because it seems to float back and forth at times, and I'm looking for a more clear definition.
Hourly
I had the same thing in the industry. I was in human resource. In the industry, exempt employees are the top level employees. Just like you don't get no overtime, you get a salary and so on and so on. Non-exempt would be hourly employees that are entitled to overtime, et cetera, and et cetera. I get confused with the same terminology here.
We need to stop using the term hourly or salary because those are terms of art for how one gets paid. What really counts is whether you're exempt from the Federal Labor Standard Act or non-exempt.
Right.
You obviously, since you receive no overtime, are exempt.
Exempt.
Whether your employee chooses to pay you an hourly rate or whether they choose to pay you in a salary makes no difference for the purpose of the Federal Labor Standard Act. It's exempt or non-exempt.
And so this is getting me to an answer.
Right.
Are all the employees who are either exempt or non-exempt by the federal labor standard correctly identified within the city?
Yes.
We hope so. I mean,
Okay.
obviously, we could be sued if we're not. If you read the definition, and it's quirky, if you read the FLSA definition of what is exempt and non-exempt, you could very well decide, my job is non-exempt, I should be getting overtime. It's a fairly strict definition that talks in terms of the person being able to generally set their own hours. They set policy. They have significant decision-making responsibility where they are. I mean, administratively, we're not consistent. We have some supervisors in the city who are exempt, and we have other supervisors non-exempt, particularly because of how we treat police and fire. They work on a shift. We pay them overtime. Even though you might have someone in another department working straight days that doesn't get overtime. But if you read the definition, it's pretty tight on who can be considered exempt, exempt from overtime. And there's probably a lot of people in Bowling Green that ought to be getting overtime that aren't. Their employers just aren't following the definition the way we might read it.
Very well. Okay. That's just.
And we do. I mean, we do have a schedule that shows all the job titles, and whether they're exempt or not exempt. So, we have something in writing to follow.
Great.
Fill-in pay adjustment. We have a policy that if a position becomes vacant for more than 90 days, we will, and someone else is to assume those duties, that we'll pay them extra to do that. Just clarifying that when someone is, say, a police officer or a firefighter and they're getting assignment pay, APO, MPO, firefighter 2, and they move up to be a sergeant temporarily, that their assignment pay is removed. And obviously the reason for that is we don't want them to be making more than a sergeant already in the job. That's already in practice, but it's not actually written in the policy. Also clarifying what happens with step increases while a person's in the fill-in paid job, to make sure they're entitled to get what they're entitled to, but again, not to make more than someone that's already in that position. We've added a provision in here where the city manager could approve assignment pay of a flat dollar amount if someone's taking on additional responsibilities without necessarily changing their job title or classification. An example being a lead worker. There would be conditions placed on that for how long that might happen. And then again, until at such time as we do a more formal classification review. Travel time. This is one we spent a lot of time on. The Department of Labor has a very weird definition of travel time and who's compensable and who's not. You could have 2 people driving to Chicago in a car. The person driving is eligible for overtime, the passenger is not. What we've done is said, here's what the federal law is, but we're going to pay people for door-to-door travel time regardless of whether they were a passenger and regardless of whether they stayed overnight or not. The law says if you have to drive from here to Washington, D.C., and somehow you come back and you didn't spend the night, no overtime. If you drove to Louisville and spent the night and come back, overtime. We're going to treat everything the same, regardless of whether you spent the night or whether you were a passenger. Within limits, the policy provides that no more than 8 hours a day. We exclude, let's say you're at a conference and they've got a social event that night. Obviously, we're not including the social event, but what's within reason. Certification pay is a program we already have, but we've added limiting that to no more than $1,600 a year. Presently, the policy says $3,600 a year. It would be treated as assignment pay, not added to the base rate, and it could be a one-time payment. The miscellaneous compensation matters, section 2-6.4, regards what happens if we made a mistake with someone's payroll. This came up for those of you that were in the commission in 2009. We had an issue we had to talk to you about where we had overpaid someone significantly. We established a process then that we're finally incorporating into the policy. If we've overpaid someone, they have to pay us back. If it went over a year, we're only going to ask them for 1 year's back. If someone, say they had a certification and they let it expire without letting us know, and we overpaid them when we shouldn't have had to, then they have to pay us back. If we've made mistakes, which we do in payroll, and we find it and we fix it, we pay them back everything they're entitled to, regardless of how many years that went on. Maintenance of the placement policy. Typically, our policy says if we have a job opening, we post it, we advertise it, or at least post it in-house. However, if the city manager combines positions and decides to select one of the incumbents for the position, that could be done without having to advertise or post it. Residence requirement. We have been requiring for the last number of years that police and fire officers, firefighters have to live within 30 minutes of headquarters. We're proposing changing that to an hour. There's obviously places in Warren County you can't even get to headquarters in a half an hour. We would still require that take-home vehicles be limited to Warren County limits.
I don't know that I'd be in favor of that, but Warren County or 30 minutes I'd be comfortable with. If it's an emergency and we're calling them in, we need them.
We've talked to the chiefs a number of times about that. They feel like the times that they've had to call people in are so limited that they have no issue with the 1 hour. You can have someone living way up I-65 and get here just as fast as someone living in Hadley or Drake. But I think they're very much in support of the 1 hour. And we're not real clear on whether we can even require a residence limit at all other than the state of Kentucky.
I was going to say, as long as they have a Kentucky driver's license, and when I was in that position, I didn't care anything about even having a time on there, because again, it was so limited and we had enough people that did not seem to be an issue, and I think that probably caused us to lose some good candidates because of our residency requirement.
I think it's not really logical that someone would live more than an hour away anyway, just from commuting time and gas. but again, we feel this is more reasonable than the 30-minute.
And again, with housing situations like they are, and I mean, this is fine with me, but personally, I just soon not have that requirement other than that they live in Kentucky, but again, that's me.
If I could play devil's advocate, why Kentucky at all?
Kentucky driver's license. It's by statute.
And what's the purpose of that?
It's state law.
We'll have to ask the state people. I'm willing to ask them too.
Here we are back to ambiguity, you know? By God, we're going to do it this way because we've always done it this way. I mean,
No, but that's the only issue is they have to have
Careful
a
with your
Kentucky
mouth.
driver's license.
One thing I'm not
The
sure.
guy got a Tennessee driving license and a policeman in Kentucky.
Yeah.
I'm not sure how our ability to monitor Tennessee driving history either, because we monitor Kentucky driving history.
I think that Slim's right in the fact that our state friends have probably, it's always been like that, probably always will be, but that's the state issue, not ours.
okay. I mean, I don't know.
You're going to be ambiguous the rest of the night, aren't you?
Well, I'm just going to be difficult.
That 15 minutes that we were talking about earlier, I think tonight is
Too late.
There are several places in the manual where we refer to fit for duty evaluation. If someone has been off of work for over 60 days, if they suddenly come in and say, I can't do my job anymore, we refer to fit for duty evaluation. And we have been doing work on developing physical ability tests for a lot of our jobs, just so that we have something in place when these come up. There's a new preamble in the employee benefits section that says benefits are not irrevocable other than retirement, and that we can change them with your permission at any time due to legislative guidelines or budgetary issues. Education assistance, we have implemented a maximum annual reimbursement limit on how much we'll pay for education assistance, and that's established by the city manager at budget time. Added that if someone goes to class during normal work hours at that time, well, if someone goes to class, that time does not count toward overtime. They're going on their own time. We have a provision that will help pay for certifications. We're proposing that we pay for the test the first time, and the second time after that it's up to the employee if they can't pass it after the second time. And that's consistent with practice we already have in place in Public Works.
If the city, I want to make sure I'm reading this right and hearing you right. If the city requires Katie to go to a class and that class lasts for 10 hours, Katie doesn't count because she's exempt. If the city requires a non-exempt employee to go to a class that lasts for 10 hours, that 10 hours doesn't count?
This is for college courses.
Okay, just want to make sure. It's something they're electing to do as opposed to being required to do.
This is under the Education Assistance Program.
Very well. Great.
Uniforms, cell phones, just referencing, make sure everybody knows that cell phones that belong to the city. They have no right of privacy while they use the phone. The records are open to subject records, and the employee has to cooperate in providing any records. Moving into leave, just adding that if someone calls in and leaves a voicemail, hey, I'm not coming into work today, I'm sick, or I text and say, I'm not coming into work today, that's not approval to use sick leave. You actually have to talk to the supervisor, and the supervisor approve it. Again, kind of references to that. Leave without pay. We have a policy presently that says you can't take leave without pay if you have any accrued leave. We could have a situation where either at the golf course they want to close because of inclement weather, and they would put the employee on leave without pay. Well, they can't because they've got some sick leave or they've got some vacation leave. Or I have a family emergency that's not medical and I need to be gone for a while. I have lots of sick leave, but I can't use that, and I have no vacation leave. Then I would be able to use leave without pay. Again, the policy says you can't have it if you have any leave. There could be circumstances where we'd want to approve leave without pay. They just don't have the right kind of leave. So this gives some flexibility there. Adding a statement that sick leave is not a right. It's a privilege. Only use it when you need to. Misuse can result in discipline. Kind of simple, but again, sometimes you have to restate the obvious. If someone's working for another employer, they can't use sick leave while they're out on injury while working for that other employer. We have a provision, when people retire, we'll convert up to 120 sick days to retirement credit. That's somewhat standard for state employees and others. Employees can actually accrue up to 180 days. Long ago in the past, those 60 days were just lost. Sometime in the early 90s, we started paying $25 a day for those 60 days or up to 60 days. This is to propose changing it to $30 a day. Again, that policy's been in place for probably 20 years without changing. We also have a policy that if someone's been out, say for a catastrophic illness, they've exhausted all their leave, other employees can donate leave to them. Our policy doesn't presently define catastrophic. Thinking about your talk about the ethics code and how some things aren't well defined. So I try to define what catastrophic is. Also, an employee who uses a sick leave bank has to go on leave without pay for 7 days before they can use a sick leave bank. Current policy allows donations without such a similar provision, but yet if someone's in the sick leave bank, they have to use that first. So this policy would also require that they be on leave without pay for 7 days before they can use days donated by somebody else. If, like I'm in the sick leave bank, if I had a catastrophic illness and I've exhausted all of my sick leave, all my vacation time, next I would go to the sick leave bank. That policy already says that I have to be on leave without pay for 7 days before I can use the sick leave bank benefits. Let's say I'm not in the sick leave bank. I didn't save my days to be in the bank, but now I've used everything up, and I want you to donate sick days, or actually vacation days to me, because you donate vacation days. The same requirement would be there. You'd be on 7 days without pay first before you get to use those other days. It's more consistent that way. Paternity leave, making references in the policy to the fact that a male could be out due to his wife or significant other having a medical issue. Also, if we have a female employee who is pregnant, that the department head could place her on modified duty once requested and verified. Vacation leave, we haven't made any changes to accruals, just also quoting vacation time in hours as well as days, but we're not making any changes to how much someone can accrue. Working on holidays, just making a minor revision as a result of the policy where we changed to the 40-hour work week. Making it clear that if someone works on a holiday, and this applies to, this is other than police and fire because they don't get the typical holidays. If a public works employee has to work on the day we observe for Christmas, that they will get paid extra for working that day, even if they had leave time earlier in the week. That's the one exception to the, you have to work 40 hours to get overtime. We've always paid more for holidays. I'm just trying to make sure it's clear how we handle it now that we have the other policy that we don't count leave as part of the 40-hour work week. Personal days, we several years ago began allowing shift personnel to cash in their days because the extra time off was causing the departments to accrue some overtime. We have typically allowed them to cash in days at the beginning of the year. We had a request from one of the departments that they also be allowed to cash it in at the end of the year. It doesn't cost us any more. It helps the employees so that they're not off as much. That helps the department so they're not accruing overtime. So again, just allowing twice a year to cash it in rather than once. The Employee Appreciation Day was added as part of the budget in fiscal year 10. We're just now adding it to the personnel manual. There are several changes in the Family Medical Leave Act as a result of a federal law regarding military service, so we're simply parroting the changes there. Commissioner Nash, did you have a question?
I got lost. I'm good.
Political activity, conflict of interest. We have a number of policies in the manual that are quite old. Some are a little out of date. What we've simply done is eliminated some of those and referred to the Code of Ethics, since that is more current, and refer employees to that. Off-duty employment, the Ethics Board developed an outside employment approval form, which we now refer to. Again, updating some things with the Code of Ordinances. We've added a section on workplace bullying. The drug and alcohol workplace policy, we have taken most of that out and put it in the risk management manual. We refer to it here, but we've eliminated several pages since the policy is in another manual now. One addition under electronic communications, prohibiting an employee from recording internal conversations without the knowledge of both parties. An exception is, of course, police detectives doing their work.
Can I ask a question on that?
Sure.
Looking at what I've read in the bullying procedure or bullying policy, if he felt or she felt that there was some kind of harassment or bullying, how would he prove it?
And there's no other witnesses?
Yeah.
Good point.
Well, isn't that the same with any kind of sexual harassment or anything else?
Yeah.
You have to do an investigation, and if you have a preponderance of evidence, you prosecute. If you don't, you wait until you do or dismiss.
Why would you take away a tool that could obviously delineate or definitively identify what the opportunity was there? And the police officers even carry them now on their person when they talk to somebody, not just in the car.
We can't hear out here, I'm sorry.
I asked why we would take away a tool that could definitively prove an issue. Even our police officers have sometimes even a video and audio recording of when they
Which
meet
one are
with
you
somebody.
talking about?
So,
Which one?
page 78, 6-13.5, recorded conversations.
Because we've had employees come in and talk to members of management, and we're recording our conversations.
Is that a problem?
I think so.
Why?
Go ahead, G. We've had a long talk about this.
I think we thought it was a good policy. I missed what you said too. Of course, we accepted police officers doing their normal, do what they want to do. But I think we thought it was improper for the city manager, for example, to bring an employee to talk to that employee about maybe some disciplinary complaint, and to have that employee unknown to the city manager or somebody else sitting there have a recording device in their pocket, and recording it without. I think our thought process was, if you want to record it, fine. Just say, I want to record it. If you have any objections, put the recorder on the table. Everybody knows it's being recorded. I also sat through a few years ago, 2 police chiefs ago, before you, I sat through a 72-hour notice meeting one time, and unknowns to us, the attorney and the 2 police officers were recording that 72-hour one. Did that bother me? To be honest with you, yeah, it did. If you want to record, fine. Just let everybody know. Don't do it in some kind of hidden method. Because I'm not sure I understand the purpose of trying to hide the fact that you're recording it. Just record it.
I don't guess I understand the purpose of worrying about whether it's being recorded if you're behaving appropriately in the first place.
Why is there a need to record it?
No.
Why give one person this in an even exchange of ideas, give one person memorialization on tape and the other person has no idea about it? It seems unfair advantage. It seems to serve no purpose. What would be the purpose of taping a conversation?
Protection,
Protection of who?
the person who's recording it.
How about the person who's being recorded? How about his protection?
If they're the one in charge of the meeting, it seems that they have all the power in that
Maybe
situation.
they're not in charge of me. Maybe they're asked to come meet with employees somewhere and they don't know that they're being recorded.
Then it's protection for that employee as well, as long as it's behaving. I don't see that I have a problem with that. Of course, I did
But
in
and
the
2
police
things.
world forever and ever. But
2 things, Commissioner. We're not prohibiting recording.
I'm
We're just
sorry.
saying, I've got it recorded and I'm going to record this. That way, what we may do, if that happens to me, I may go get a recorder and say, fine, you've got your recorder, I'm going to record it as well. Because today's technology, you can change recordings. And the second thing, now all of a sudden we got a public record out there now that we don't know about, because that recording is a public record.
I don't see an issue with it. To me, it's more of a protection for the employee who has either a bullying or a harassing boss. And I think it's a great tool for protection for everybody.
We disagree.
Section 6-13.6 regarding social networking sites added some policies warning employees about posting information representing themselves as a city unless they're as a representative of the city unless they're authorized, being critical, incorrect, posting information about other individuals, and not linking to any personal websites from the city's site or other social networking pages. Employee relations to miscellaneous policies, we've added the smoking prohibition that was adopted in 2007. Also, certain offenses that should be reported to the supervisor, such as if they drive a city vehicle and they've had an off-duty accident requiring a police report, to report that. Also to report any arrests, convictions, indictments, or DUI. We've added workplace bullying as a cause for disciplinary action, as well as improper destruction of city property or official records without authorization. Again, if they've been arrested or if they're aware of a criminal investigation involving or about themselves, if they fail to notify the supervisor, that's grounds for disciplinary action. We've also added violation of a city policy or procedure relating to the manual, the ethics code, or the computer ethics policy. The computer ethics policy, we've had some language in this manual from that. We've pulled that out and referred just to the computer ethics policy. Regarding penalties, just added a general statement, again, trying to protect ourselves that while we intend to use progressive discipline, there could be a serious discipline issue that causes to skip a written reprimand and go on to higher levels, that sort of thing. We've clarified that a demotion, according to the city code, if a demotion is due to unsatisfactory work or discipline issues, that requires city commission approval. Same if there's a termination for unsatisfactory work or discipline issues, that requires city commission approval. Referenced previously the pre-disciplinary conference. If we intend to suspend, demote, or terminate an employee, they be given the opportunity to meet with their department head to rebut, clarify, or present evidence. This should be informal. No attorneys need to be present. And it would not be required if the employee accepts the discipline or if they're being disciplined because they're unauthorized away from work. Termination pay due to death. We've added some provisions that if we have an employee die, we would continue to pay the rest of their paycheck, and also provide some provision to continue coverage for their family members on medical insurance for a period of time at no cost to them. Question asked, non-exempt personnel eligible for paid overtime or paid for comp time if they terminate exempt personnel or not. If we lay someone off, they don't have the right to appeal or grieve the action. And I've just mentioned the one about continuation of health benefits in the case of an employee who dies. Any questions about items that I didn't go over here right now? Or?
On the issue of a laid off employee right to appeal or grieve the action, still doesn't negate the fact that they could obviously take it to circuit court if they wanted to.
True.
Right.
I guess we're looking for somewhat of, we want to present this for approval next meeting, and want to know what changes you wanted to make to this. And we can amend those here or add some other ones if you like.
I voiced the objections I had to those provisions.
I would agree on page 78, item 613.5, the recorded conversations. I think employees should be allowed to record those conversations with you all knowing they are recorded.
With us not knowing it.
No, with you knowing that they
Okay.
should tell you.
That's
all.
how we have it written.
Okay.
We just think it's fair. 'Cause
Can there be any provision written into it, Mr. DeFebo, that would allow if an employee feels like they're being
yes. They could go-
discriminated, you know, I don't know what the proper wording would be, but that they could record a conversation without both parties knowing if they feel like they're being discriminated against
Yes.
or bullied,
Okay. Yeah.
which would
Yes.
then allow them not to have to notify the potential discriminator or bullier, hey, I'm recording this conversation.
But basically, they're trying to gather evidence of their own investigation.
That's-
Well, that they could
that's
take
what I was
forward to their
alerted to. Thank you.
supervisor to say,
Gene, I think you're the harassment officer, aren't you? You're not the harassment investigator of stuff?
Michael.
You know, Michael. So they need to file a complaint, then Mike sets that up, and if they want to tape the conversation, fine. The issues that brought this about had nothing to do.
and I
think
agree.
you
I
all
don't,
know what the issues were.
I don't
understand
think
what
an
you mean,
average
yeah.
conversation should be allowed to be recorded unless both parties know about it. But I think that if they're wanting to approach their supervisor and what they want to do about some kind of discrimination or unfair treatment, and they
That
want to
should be
record,
pre-authorized by Michael, I think, with Gene's civil rights input on that, I think. Legal protection of this.
But we can work
I
out-
think that's legitimate, because you need people to talk freely. We just don't want to be in a situation where every time we talk to an employer, we're worried about whether or not they are taping us and they're going to put it on the radio or on the blog or on YouTube or whatever. This is a new world now.
yes, it is.
But so you're talking about, and I agree with that, helped clarify what I was talking about. You're talking about harassment or criminal activity, number one, harassment, bullying, what was the fourth one?
Unfair treatment.
I said discrimination.
Discrimination.
Yeah.
Yes.
Okay.
I think that's appropriate investigatory uses, because we, like, as you know, no one has a right to privacy for their email, and we use that for exactly those reasons. That we have a protocol for that. It's not anybody can look at everybody's email. We have a system where now people have to go through a protocol to do that. I think that'd be appropriate.
Any other?
The only issue that I have, go back to the residency requirement, and I don't know if there's any support on that or not, but again, I don't see any reason to have that as long as they comply with state law. I don't see any reason to have a residency requirement, but again, I may be
Residency in Warren County?
Or anywhere.
anywhere,
Oh,
You talking about for policemen?
police or fire. Again, I think that probably limits our pool. Some, I know I've dealt with a few people that lived, at that time it was 30 minutes when I was in that position, but they lived an hour and a half away, and they've been excellent candidates, but for some personal reasons or something, they couldn't move. So
it
again,
relates
just
to
throw
the
that out.
car also.
They leave the car in Warren County.
Oh.
Yeah. And I understand that.
Because what you could have, especially with the fire who work, 3 days, maybe a week?
Right.
Right?
Yeah.
They could live in Litchfield and come down
Yeah.
for 3 days and
Louisville.
take a city car. In Louisville, and take a car up to Louisville.
And I don't know from the fire perspective, but I don't have any problem. And again, I may not have a consensus up here, but I don't see a residency requirement for police or fire. But again, I'm only
So
one person.
you're saying that the person, but the car stays in,
Yes, yes.
Okay.
That's the way it is now.
yeah.
If they're an hour away, the car doesn't go out of Warren County.
So we are requiring our policemen, as well as department heads, which is different, to move to Warren County, or live in Warren County.
Now, the present policy, department heads have to live in the city limits. Police and fire are supposed to, if they don't live in Warren County, they're to live presently within 30 minutes of headquarters. The proposal was to change that to an hour. And they have to live in Kentucky. Anyone that a job requires them to have a driver's license has to live in Kentucky. The option here is that we remove the 30 minutes and an hour and just say police and fire have to live in Kentucky.
I guess some of mine is that if someone lives an hour and 5 minutes away, then they're exempt. And then what's an hour? Is an hour in traffic? Is an hour as the You know, do I get my GPS out? How do you prove those things? I think you just get into some possible litigation issues. And again, I think we're losing some good people by limiting ourselves. And again, Todd would know more about the fire than I would, but with their days. But
That is one of the issues we did talk about a little bit and talk about this policy was, 30 minutes, is that 8 o'clock in the morning, 2 o'clock in the afternoon? Is that on a normal day, in a bad traffic? I mean, like I said, 30 minutes out Scottsville Road will basically get you to the interstate.
yeah. And again, when you look at somebody and they say, I live so-and-so, then you say, well, you can apply, I'll drive it at 2 o'clock in the morning and, I'll get there in under that hour. So I just think it's more regulation than we need, but again, that's just, and I've thought that for a long time. That's not a new decision for me. I lost that battle 5 or 6 years ago too, I'll have to tell you.
Bruce?
Well, the reason I say otherwise is they're all used to operating under the rule that we have, and to change it, I don't think is necessary. But the further you are away, I know that the supervisor, in case of emergency, is going to call who he can get there quick. The guy furthest away is going to be the last one called, so the guy living close is going to get all the extra calls. He may want them, he may not, but they all ought to be treated equally, and the further away you are, the less you likely to call.
I think it happens so few times, I don't know that it would even make any difference. But again, I see one part of it, I see what you're saying, obviously, but I just don't agree with it. But that's me. That's Bruce and I's relationship. I just don't agree with it.
But I guess in this case, we're only thinking of police and fire, and I'm thinking of public works and inclement weather. On one hand, I think it's kind of silly as close as we live to the Tennessee border that they have to live in Kentucky. Because you could be, 20 minutes and be in Tennessee? Maybe I'm telling on myself.
Well, you drive, yeah.
10 minutes here at the line, I understand.
But I do see some merit to there being some kind of time limit to get here. So I don't know. I struggle with that one. I see what Bruce is saying about the guy who lives closest is going to get called more often, but the guy who lives closest is always going to get called more often, whether he lives an hour and a half away or whether he lives an hour away or whether he lives 50 minutes away. That's just the nature of, if you have to have somebody there, you got to have somebody there. But how does public works? I mean, I hear on a fire department standpoint, from at least an old police department standpoint, mature police department standpoint, it comes up less often, but how often does it come up related to other departments, specifically public works, inclement weather? I mean, I'd like to hear, I guess I'd like somebody to talk to Bobby Phelps about it or to Jeff and say, how often are you calling in employees?
Yeah, Kate took the baton for 6 months or so?
Back this past winter, of course, we had 5 different storm events, and we had to call in public works employees, fleet, and operations when we had to plow and take care of the streets. Generally, Bobby tracks, the public works operations manager, Bobby Phelps, tracks weather and anticipates the need for when an employee needs to be called in. So he sets up shifts. They're a 12-hour shift, and he already has a list of who's on the first shift and who's on the second shift, so that they're ready to go in advance of that. And they know that they can't be too far away to be called in at that point.
So there's not surprises there.
Right.
Okay.
And in talking to the department heads, people are not going to live that far away, particularly public works, where they have to come to work every day. It doesn't make sense to travel an hour and a half or 2 hours to work. So most of them are going to live in Warren County or an adjacent county. And it does come up so infrequently that probably eliminating a residence requirement other than Kentucky, because of the driver's license probably doesn't affect us that much.
There's not take-home vehicles in the other departments that are really pervasive. What, 3 in Public Works maybe now? 4?
Or who's on call.
I know of
perhaps.
a person that would have applied with us.
Can
and
I
the
interrupt for
peop-
just a
Yeah,
moment?
yeah.
I'm sorry to bow out. I promised my daughter I would be at her open house, and so I'm going to step out of the meeting. I'm sorry.
Very clear, that was not ambiguous, what you just said. Well, I remember a person that would have applied with us, but they lived on a family farm, that they weren't going to give up the family farm. They would have been an excellent candidate, but they were probably an hour and a half away. And they were willing to do that, and I didn't see any problem with it personally. And they knew about the car situation, all those things, so.
What says the commission?
The other issue Bruce brought up and we probably should discuss is number page 1, through 2, 3, 2 point B.
What do we do about, what is the feeling on living in Warren County? It's the 4 of us, it doesn't make me any
We
difference.
require Public Works people to live in? It doesn't apply to
think so.
Public Works people.
Only police and fire, as I understand it.
Yeah, do we require 30 minutes for police and fire? Do we require an hour or no requirement at all?
If you're having a requirement, I would prefer miles versus time because it goes back to your time. How do you determine the time?
You got a problem with peace officers. There's a state statute that says you cannot establish a residency requirement on peace officers in Kentucky. Nobody else, just peace officers, but you cannot have a residency requirement. That's and based on that, I think a lot of people have gone to response times to try to get. But I think if we start going to a distance, you may be causing some issues about potentially violating that statute.
I know how to avoid the issue.
Okay.
Don't have residency requirement rather than what meets state law, but yeah. That may be something, maybe you want to ask the chiefs what their,
You already indicated.
that
Yeah,
either way.
Yeah, they were, I think they were more in favor of the hour than none at all, but I think if they hear that there's some interest on the commission, that there be no requirement, they'd
And
probably
again,
go along with it.
Kevin's talking about changing issues. That's just another, that just seems archaic to me, to require that in Bowling Green presently, but again, just one thought.
I think the opinion I heard is, at some point, the commute is going to be too far. Someone will not take the job or keep the job if they're going to have to keep traveling so far to get here.
So what is the feeling? No time, no mileage, no distance? Melinda?
We can't do that because of state,
Okay.
so I didn't realize
Just as long as
that.
they live in the state of Kentucky?
If he doesn't want that, you want
Or
to
just as long as they,
I can count to 3.
what do we do?
Did I understand it? You have missed out, when you were chief, you missed out on some good employees.
I think we missed out on several good applicants because of our, at that time, we were talking about 30 minutes. And again, I had a difficult time what 30 minutes was and where you're coming from. And sometimes you can't make it probably from Alberton to the station in 30 minutes. But of course you were in Warren County. I'm being a little bit facetious, but I thought that it cost us some employees, and I thought it was just a regulation that seemed to be overburdensome on some people that could have been great employees.
I'd say have no limit then.
You know what?
Don't have the time limit, the
Okay.
drive limit.
The same thing you were talking about?
No, sir, I was doing not changing it.
What was the
but-
other item?
Oh, it didn't make me any difference
I
whether
wanna
we
see
change it or
managers
not.
get The average.
What'd you
Which
say,
you
Mike?
know I'm
We didn't
okay
hear you.
with.
I was asking the city manager what the other issue was to discuss.
2.2-3.2B, which is page 8.
The additional compensation.
Again, the way our pay schedule is set up right now for all but department heads, the pay schedule actually tells us what the step increase is for each of those pay grades. For senior management, or for department heads, excuse me, that schedule does not have a dollar amount. What we propose in the manual is to say that senior managers on Schedule D would be eligible for an increase, performance increase rather than a step increase based on the average step for Schedule G and S, which is the general employees and public safety. So we'd take whatever the average is and say that's what senior management gets, but the senior manager could award additional compensation based on meritorious service. My interpretation is that also means that if the city manager doesn't feel the senior manager is performing very well, he can also give him a 0% step increase. And that's why you would allow more for meritorious service, because it's not a more automatic step compared to what the other employees would get.
And you could also vote no.
That comes before us, before it's actually done, correct?
No.
No?
No,
That's the part of it that's outside the
Not
norm
for
of.
senior managers,
Everybody's pay comes before the commission.
not individually.
But we have a pay chart where everybody gets what the
That-
percentage
The
is.
pay schedule comes before the city commission, but that's not individual salaries or raises. That's pretty much
That's my only
defined by
objection
policy.
is that we vote on it. If it's going to be beyond what you delineated here, additional compensation based on meritorious service, that you bring it to us like you do
I have
every
no
other
I have no problem with that at all.
pay plan.
I think that's, as Mike knows, I was for the more bureaucratic approach to just a 2-point something, because that just makes it, but it's not fair to people both ways, who underperformed and those who overperformed. If you want to add, if the commission wants to add the thing to bring it directly to you, that's right order. I think that's appropriate.
Because it affects the budget.
But it goes, it's not that we don't trust the city manager, but if we give him that authority, why do you not give the department heads that authority to go beyond for those meritorious employees, or for that matter, the next level of management down, or even supervisors? So,
Because they have
Well-
steps. They have a structure. We have no structure.
but he's defined the structure here. Here is their performance increase based on the average step for Schedule G and S employees.
Although it does say may be eligible for an increase. Senior managers may be eligible for an increase, not shall be eligible.
Remember those dark days when we looked at pay for performance and
Right.
those were dark days. If we'd ever gone to that, it would have been terrible.
Okay, so the provision, we would add in a provision with BOC approval, the city manager may award additional compensation based on meritorious service.
Sure.
Okay.
What else?
I'm sorry, I didn't see 3 people on that one. I saw 2 of you.
I'm good with that.
Okay.
Yeah, everybody.
I want to thank Mike, if that's okay with you all, and Kate, and all of us worked on this, 3 years maybe?
2.5.
Seems like it.
Yeah, and the employees have got this on the click, right, Michael? And
That's one question, I'm sorry, I had. Were the employee committees involved in reviewing this material?
Not in reviewing this, issues that they brought forward to the city manager were considered in preparing it, but senior management has seen this, but we did not present it to employee committees, because this is an administrative policy that we would bring to you first. And once we get your input, then we'd start sharing it more with employees.
plus some of this stuff is what you've already done, unless you want to invite the employees to negotiate with things you've already done.
My comment about pay for performance was because of the process, not that the employees, it is and it isn't. It was just the process. The pay for performance, it was terrible.
That it?
We intend to bring it next month, at the next meeting, so, because we've been,
Anything?
thank you.